going to go ahead and start. All right, we're calling the meeting of the Southeast Consolidated Zoning Board to order. We could get a roll call, please.
Dennis Bolin,
Present.
Ken Klingensmith,
Present.
John Lloyd,
Present.
Dan Foyle,
Present.
Fred Wingert,
Present.
Kelly Rast,
Present.
Emily Coleman is absent. That makes 6 members present. We have a quorum.
All right, thank you. If you could read the hybrid meeting statement, please.
This meeting is being recorded. Please silence all electronic devices. Please note this meeting is being held in the board hearing room with zoning board members attending in person. There is also an option for virtual attendance on Zoom webinar. If you are using Zoom, you may participate in the meeting using your computer, telephone, or other electronic device. For Zoom participants, chat will be disabled once the meeting begins. If you have trouble, please call 913-715-1700. If you would like to speak, please use the raise hand function in the Zoom app to notify planning staff of your desire to speak. To activate this function, click raise hand in the webinar controls at the bottom of the screen. By telephone, you may raise your hand by dialing *9. We will take comments from in-person attendees first, followed by Zoom participants. The Zoom moderator will call on individuals who have raised their hand. The chairman may modify these procedures as needed to conduct an orderly and efficient meeting. All public speakers will be limited to 3 minutes unless the chair designates a different time period. When your name is called by the moderator, your microphone will be unmuted. Please state your name and address for the record, followed by your comments. If you share concerns, comments, or points made by others, please refrain from repeating those comments and instead note for the record that you agree with the previous individual's comments. There will be a 10-second remaining warning sound. Board members and presenters, please state your name each time you begin talking so that comments can be transcribed for the record. This is a public meeting. We are presenting live and recording the meeting. Thank you.
Thank you. Okay, agenda items. Assuming we don't have any changes to the agenda. Since we only have one thing in no cases. Okay. Disclosures of conflicts of interest. Or external contacts and discussions.
I would like to just note for the record that I spoke with Commissioner O'Hare regarding clarification of board appointments and the confirmation process.
Okay. Thank you. All right. Anybody else? Anything else? Moving on to approval of the minutes from the last meeting.
This is Ken. I reviewed the minutes and make a motion to approve the minutes as presented.
Kelly Rast, second.
All right, we have a motion and a second to approve the meetings of the January meeting. All in favor, say aye.
Aye.
Aye. Opposed? Okay, meetings are approved, meetings of January meeting are approved. Board reports.
Good evening, Chairman, Commissioners. This is Sean Penley, County Planning Staff. I have a couple of updates for Board of County Commissioners actions and Planning Commission actions. For the Board of County Commissioners, for all the cases that were considered by this board, January 4th meeting, we had 3 cases. There was a preliminary and final plat for 319 Delaware Street. That was the Mount Auburn second plat. There was a rezoning and preliminary and final plat for 183rd Street Mission Road. That was the estates of Shadow Run. And then there was a final plat for Bell Farm at 21378 Renner Road. Those cases were all recommended for approval by this board, and those cases are scheduled for the Board of County Commissioners meeting tomorrow in this room for final action.
Okay,
Like I can give an update on Planning Commission.
yes, please.
The Planning Commission, we had a meeting last week on January 24th, and at that meeting considered several items. There was the 2022 year in review for all the cases and actions that were considered by the Planning Commission last year. There was a 2023 strategic plan list of upcoming projects for this year for the Planning Commission. We also considered the first round and review of draft amendments to the regulations for accessory buildings. If you recall, we have been discussing with the zoning boards and with, I think, the Planning Commission too, about changes to the regulations allowing for larger sizes of accessory buildings and a different review process rather than conditional use permits, since they become cumbersome and having terms. We're looking to adopt a different review process to avoid a conditional use permit. So they've considered the first round of review on those amendments. They'll come back before the Planning Commission for a hearing, and then ultimately the Board of County Commissioners for adoption. We also had at the last Planning Commission meeting some updates on some of the projects we have for some long-range planning updates. One of those being the airport updates. Both the New Century Air Center and Executive Airport are going through land use compatibility plan updates. So we've had some meetings with the subcommittee of the Planning Commission to look at those updates. They also have advisory committees looking to discuss that. So we have representatives from all the cities that are affected and members of the Airport Commission, Planning Commission, and staff. So we've had those first two meetings. We actually had one just yesterday. Was it Tuesday? Tuesday. Yeah, to talk about the advisory committee, and we had a stakeholder meeting as well, a developer stakeholder meeting for different developers and property owners in areas around both airports. That went very well. Got some good feedback from the development community. And then we have had a public workshop. We had a public workshop last night for New Century Air Center in Gardner, and we'll have a meeting next Tuesday, a public workshop for the Executive Airport update. That meeting is next Tuesday, February 7th, from 6 p.m. to 8 p.m. at Johnson County Executive Airport. That concludes the updates, and ask if there's any questions.
Questions? Okay. All right. Moving on to business before the board. We have just one item this evening, draft zoning board bylaws. Peg Trent, Chief Counsel.
Good evening. Thank you. And I appreciate the opportunity to review a draft copy of the bylaws for your consideration and discussion this evening. Just to give you a little bit of history, state statute requires that zoning boards and planning boards have regulations over their business and how they conduct themselves. Those regulations are also within the subdivision regulations, and regulations also requires you to have rules and regulations. This board, specific board or consolidated board, and what it covers was formed in 2017. There were various zoning boards that had some of you, but there was a consolidation that occurred in 17. Even before then, zoning boards did not have bylaws as required by state statute and our county regulations. There was last year, just so you're aware, Ed Eiler and through the commission requested a subcommittee be formed. It comprised of Commissioner Hanslick, Commissioner Myers, and Commissioner Fass, and myself and Linda Sater, the clerk of the board, to review the current rules of order for the county commissioners and code of ethics. At that time, during the review in 2021, and due to the solar application that was going, or discussion for regulations that was going in front of the planning commission, that's when it was discovered that there were no bylaws for any of these boards. So the planning commission did, and some of the members, Kelly Rass, I believe, and I'm not sure who else on this board was present, but Kelly Rass, I know, was present. The planning commission undertook the first attempt of doing bylaws. Planning commission is different, as you know, than zoning. And zoning has has several responsibilities of reviewing applications, as you know, as opposed to the planning commission is more of a legislative. So the planning commission went through, based on the rules that were in effect with the county commissioners at that time, and adopted a version of those rules, bylaws. Those went to the board. They have to be approved by the board as well. And there was a revision made concerning conflicts of interest and my role in determining such. And those are what's in effect for the Planning Commission. However, since the subcommittee convened, there now has been 3 cows that have occurred, committee of the whole of the county commissioners, where they reviewed the rules of order. And after those discussions and the direction, and for tomorrow, will be on for consideration of the county commissioners. There is discussion specifically of changing some things that will affect the bylaws. So eventually we will, if those are passed and adopted tomorrow, we'll have to go back to the Planning Commission to revise to be consistent with the Board of County Commissioners. So at this time, last week, I started the journey with all of the zoning boards going through the bylaws that would apply to zoning boards, utilizing projecting, because I've been going through the COW with the conflict of interest. On January, I think it was 12th, we started meeting. That's the day we discussed conflict of interest. And the board, although it's not binding on the board, directed staff and voted on this type of conflict of interest clause. Then we met on the 19th and the 26th. And the reason I'm bringing that, so you know kind of the history of what brought forward this clause. If they adopt it, then I had included that in Southwest Zoning Board, met with them last week. They did not adopt because we're waiting to see what the board does. And there were some revisions because they had outstanding questions that they had. So all of the questions that they brought up last week in that board and were really, and I can go through those that they brought, we incorporated in this document. So this has been somewhat taken from the Planning Commission. Now what I know potentially, I don't know for a fact, but if it goes forward tomorrow, the rules of order, what would be in that zoning bylaws, and then their questions, because I revised it. So they have not adopted these rules yet, bylaws. They'll come back in front of them next month. I'm not requesting nor asking you to adopt tonight because we don't know what the commission's going to do tomorrow. In addition, we need to incorporate if you have any questions or revisions to these bylaws. But what we're trying to do is have a template so that we have consistency among all the boards. So I'm not going back and doing, this board has it this way and one has it a different way. We want unity in the way that we're doing it. And so it is my intent as I get through the zoning boards to schedule to get on the Planning Commission to go back to remove some of their clauses. So essentially, you've had this document. I'm not going to read to you all of it. It is basically regurgitating the jurisdiction of this board, what petitions and applications you review, your authority under state statute, getting into your purpose and mission. And I guess I'm just going to jump down because it seems that that's of the interest prior to the meeting is conflict of interest. And that's on page 3, paragraph 4.06. And this has changed, just to give you a broad brush. The previous conflict of interest had this language about state statutes. So you're aware county commissioners are as elected officials and have to follow the state statute on local conflicts of interest. And even though they fill out the statement of interest when they're campaigning and elected, it continues their obligation under state statute. And if they don't comply, there is a misdemeanor penalty. In addition, right now, this is before the board, and you have to know because we want consistency. The board right now also has the rules, the code of ethics and the rules of order, which indicate that not only do they do the local conflict statute, but in addition, they do what's in that first sentence, a pecuniary interest in a matter pending before the board that derives some direct or intangible personal professional benefit. That's in their current rules, I believe, as well as that next sentence. So that first sentence in their current rules. But what was removed, if you will, is the appearance of impropriety. And the reason that was removed is because it's too overly broad and subjective. We saw on the Planning Commission when the solar regulations came through, all of the conflicts that were occurring due to appearance of impropriety. But some of them were, I would submit to you, fall under that pecuniary, some of what I'm not allowed to disclose due to confidentiality, but some of them did deal with the first part, so they would have been excluded. But there was one particular individual, just because someone came in and testified, that person got disqualified because of employment, and that was on a basis of appearance of impropriety. So that's overly broad and subjective. We see a lot of this in many regards that I've seen where people will donate to different organizations. And so then that's the appearance of impropriety. It's very broad and subjective. So yeah, let me finish and then I'll take questions if you don't mind. Just want to finish that. So it is very broad and not measurable. And it's very, hard to maneuver. I don't know unless somebody complains whether someone has a conflict. So I recommended, and talking with the subcommittee and then bringing it to the Board of County Commissioners, that we measure based on the local conflict statute. The only difference is when it applies to you as a board, you don't face criminal charges. That's only the elected officials because they're the ones that fall under the statute definition. The board and others appointed officials, which would be myself, the county manager, potentially, I don't know what I'm speaking ahead before the board has reviewed the code of ethics. We're suggesting that they all be applicable to the same standard, that we fill out, and I'm going to show you a statement of substantial interest, and that's filed with the chief counsel. And I have the ability then to review those through that process to make sure I'm looking for conflicts, or my team who's on tonight, I think Ryan Haga and Bob Ford, who do the planning and zoning boards, are looking when you have items to see, do we have a conflict from your form, what you've reported. That form has to be updated. And so we are requiring also, and it'll be in the code of ethics if it's adopted. So again, this is into the future, but I'm trying to lay the foundation so you know what's coming. You would be updating it whenever something changes, that you would have to update on that form. And that would be with the chief counsel's office. So as long as you're filing that form, we're looking at it. That doesn't mean you get to just walk away and don't have a conflict. It just means it's more measurable for me to know if you reported it. And then if you reported it, I'm going to look to see, do you have a pecuniary interest? I'm going to look to see if you have a substantial, and if you do, then you have a conflict of interest. And what that means is you are recused. You need to recuse yourself from this, from voting and on that application that would come before you. We are still in I have to bring to a CAL on February 9th, the code of ethics, which will outline that process of appeal and how that would occur if you disagreed. But right now, the purpose is to get us to a standard that's measurable and still accountable. Different members may have different other reasons that they're under of confidentiality that precludes them from going public. It would not be the intent, and I know there's been a discussion, you would indicate that you have a conflict, and the conflict would be conferred with me, that they would just put that on the record, they have a conflict of interest, and put that they're recused. There's also been discussion, you have to leave the room. It's my opinion, you do not need to leave the room. If you have a direct financial or something, there may be that I may say, hey, it may be best, because I know with Planning Commission, they were handling some pretty controversial legislation, and there were a lot of actions occurring behind the scene, and it's hard to protect board members who are getting attacked from the public. So it was easier to tell people to leave the room. But the rules at that time for the commissioners were to leave not for the Board of County Commissioners, but for the Planning Commission was to leave the room. And that was a lot because I know they're doing some controversial legislation. At this point, I'm not recommending you have to leave the room. If you feel more comfortable to leave the room, then you can, but you cannot debate. If you're the chair and you're the conflict, you cannot chair. It goes to the vice chair. And if the vice chair has a conflict, then it goes to the pro tem. The reason we're also requesting that you not leave the room is we want you to be included in the quorum because of the number. What happens if you start conflicting many people off, like we saw in the Planning Commission? We barely had enough to even vote, to even have a quorum to go forward due to conflicts. And a lot of them were broad with appearance of impropriety that, that shouldn't have been and shouldn't have happened, in my legal opinion. So at this point, the purpose was to try and have a process that is fair, measurable, that my office can look at and find definable conflict. Did you disclose it on the form? If you didn't, if you disclosed it on the form or someone brings evidence that you didn't disclose it, then that's going to go to the county commissioners potentially if we do the code of ethics for, discussion, if you will. Again, that policy is not in front of the commissioners at the time. So this could all change, right now, but I wanted to start having that discussion with all the boards. So I'm going to pause. Before I begin, I wanted to bring up the form for you to see, so you can see how detailed it is. Okay, can you help me? Thank you. So this is a statement of substantial interest. This would be housed in my office for the board. It would not go to the staff or anyone. We would keep it confidential. So essentially it gives your name, your spouse's name. We're looking for all of those under state statute. We're watching the state statute and how there's conflicts. We will revise this form because we will not put office held, but you are appointed. So that's where you would be, you have to put in your ownership interests in any of these corporations, proprieties in the past 12 months. This form has to be kept up. If you end up getting another partnership and you didn't disclose it, that's a problem that you didn't report it to, that we want to see it. And that's more so for the commissioners because it's a crime if they aren't keeping their forms updated into what their interests are. These forms seem simple to fill out, but they're not. I can tell you by looking at people, I don't think they're filling them out correctly. So we would make sure that we teach you and work with you. There's instructions and making sure you filled it out in this initial round to make sure everybody is in compliance. It also gets into gifts in goods. So you're looking at, have you given gifts to certain businesses? And we're looking at this so that we're keeping track. If you're making huge donations and you're doing certain gifts, we want to know about it. We're going to look at that if you have a pecuniary interest in that financial transaction. We're looking at where your compensation, where you're employed, where you're receiving your money, because to us, we're measuring financial. We want to know you don't have a financial interest in the outcome of what's coming forward, or personal in the indirect or benefiting in some way with your spouse. So we're looking at all of this, and it's pretty detailed. Of all organizations where you're an officer on another board other than this one, you would put this one too. Anywhere where you're receiving fees and commissions in $2,000 or more, that's very low bar of $2,000 to some people. So you would have to disclose clients of where you are receiving $2,000 or more, unless, not unless you would have to disclose from the firm. Now, the question becomes, some people are under a non-disclosure, or as an attorney, I think we have attorneys that are on boards. They have a professional responsibility where they can't disclose clients. They're still going to have to do conflict of interest checks with their law firm on every matter and running it through legal to make sure that they've done a conflict check too. And it's my intent that we'll put this all in process so that there will be a procedure for that occur if you're an attorney or you're under a non-disclosure agreement where you can't disclose that you're doing business. But disclosure to me is the same thing, so that we know whether you have a conflict. So the key is disclosing. And if that's so that we know when we're putting a mechanism in a process. However, if you don't disclose and the public comes forward, that's a complaint, an ethical complaint that could result ultimately in your removal potentially from the board. So that's why we're trying to make sure that we're utilizing this form. Now, this form hasn't been adopted. I'm just saying this is the statement of interest form. It's something I'm proposing. We may do some edifications, but I think if we do the conflict of interest with the substantial interest, we may want to make sure you have approved the form. The form's approved for everybody. So these rules would not get approved until after the board makes that decision, the Board of County Commissioners, and that's the direction they want to go. So that is the only, if you will, clause, if I recall, that was some questioning as to. And then with that, I stand for any questions you may have then.
Okay, Kelly Ross, I have a couple of questions. There's a lot to unpack here. So first question, pretty simple. If you're on an NGO board, does that need to be disclosed?
A what board?
NGO board,
What's an
Non-government
NGO
organization.
board?
non-government organization board.
Yes, on this form, can you pull that form? I'm sorry. Yes, you would have to disclose all those boards.
Okay.
And it used to be in the old days, I think this is what I was told, that legal used to check out every appointment in this regard. And we don't do that. So this form, you have to, if I can scroll back up, there, officer or a director of any organization or business, you have to disclose.
Okay.
So then I would have that on file. And so when we're doing a conflict check, and it's going to be a lot of work on legal, but the guys are online, they're going to have to go through on the applications and making sure.
Okay, then one of the things that you had said that I just wanted clarification, you said, if you have to recuse yourself, but you're still here as part of the quorum, would you, because you have a conflict, would you have to abstain from voting?
Yes, you would abstain
Okay.
from voting, but you're included in the quorum. And Robert's Rules of Order allows for that.
Okay.
That you still can be accounted in the number for the quorum to vote, but you're an abstention. So it would reflect, so a majority, passing as a majority is of those who are in the quorum. So if I have a quorum, and I correct this because I know last week when Commissioner O'Hara asked me in a cow, I got nervous by what was being asked and didn't understand. So let's say you have a 7-member board. You have 4 people present. You have 1 who abstains. They're still counted in the quorum that you have a quorum of 4. But then you're going to look to the remaining 3 to see if it passes 2-1.
Okay. So
You
there's
see
just
what
a
I
body.
mean? Yeah.
Yes. Okay, I got that. Thank you. My next question, so like, you can kind of provide some clarification from this standpoint, because a lot of the BOCC members are on different boards. And one of the things that I had some trouble digesting was the board, some of the BOCC members that are affiliated with MARC or the Climate Action.
Mhm.
And there's a lot of entanglement there. And with being on the Planning Commission, obviously, and doing the solar stuff, that there was, to me, a lot of evidence that those board member, BOCC members should have recused themselves. So how would you
That's a good
answer that with those?
That's a good question. There are boards where we have, I can just say state statutes I can point to, where the legislature has deemed that certain things are not a conflict, and they will have, like I can say, we have one of our commissioners is a voting member on the Parks and Rec per the state statute. To me, that's interesting.
Well, and that's fine. I get where you're
But what
going
I
with
guess
that.
I'm trying to tell you, it's not uncommon that you will see different boards that are set up like compacts that we have with Mark, and different items that you're going to have appointments to different boards and liaison assignments. So they're not voting, they're just liaisons.
Okay, and again, Kelly Rast, I hear what you're saying, and I don't really have a problem with what you're saying. But when Mark or the Climate Action, different people are calling in with a very specific side, on an agenda, okay, the solar farm, we clearly knew where their position was.
So you're claiming that
So
the
if you're-
commissioners were biased.
Well, no, I'm not claiming anything. I'm just stating some facts that took place. I don't, how is that not a conflict of interest if you know where that board stands on a particular item to the point that they're actually calling in and giving their testimony why that this should be a good thing, yada, yada. And yet you have people that are sitting on that board who also are in the influential position to vote. How is that not a conflict of interest?
That's not a conflict under this new proposal. It's not a conflict and it would not be a conflict under appearance of impropriety.
Please explain.
Let me explain. Yeah, I will. It's no different if you have personal feelings about certain positions on political positions. You come when you're elected, and this is not applying to you as a board. I'm talking now about the BOCC. So you're asking me questions that have nothing to do with you, but to do with, I'll answer them because I think, just I want to make sure I respond to that. So with BOCC, they're elected officials accountable to the citizens. At that point, they were elected. I'm going to do this. I want to do this. I want to bring this. Every one of them make campaign promises. They have positions. They have beliefs. That's why they get elected, because you want like-minded people who have policy positions. So everyone comes to that board as an elected official with some preconceived or bias.
Basically, you've opened up the door for everybody to have that same position on everything.
So
we
that's
just
why
come to the
appearance of
table with our own
impropriety, if
personal.
we were to apply your standard, would be, it's insane. It's subjective. So what happens is an individual, if they have a conflict, a true conflict, sure, they should be conflicted off. But, it's no different if you have another position on another matter, and I won't get into, giving examples of a commissioners to call in about anybody, because it's great to have positions and have diversity in opinions. But the fact is right now, that's too broad appearance of impropriety.
So if I was on the board of directors of a organization that was against solar and I'm on the planning commission, I'm fine to still sit on the planning commission and
If I'm on
address
an organization, no.
the solar farm?
No, because
Well, then you've got people that are on,
under conflicts of interest for a board member, because you wouldn't on a solar planning commission. If you've disclosed that that's where you're affiliated, that would be, these are called substantial interests. This is a form of substantial interest that the state and others have identified as when you have a substantial interest. It's very definable.
Mhm.
So if I know it's on the form that you disclose this, then I know you have a substantial interest. And therefore, before you even voted, I'd be coming and saying, hey, it looks like you have a conflict as a result of what you disclosed. Now, I may not know it because you didn't disclose it, but if someone complains and I find out that that is the case and you didn't disclose it as a board member, not a BOCC member, board member, then at that point, that is an ethical violation. And that could be potential maximum removal from the board, planning commission, or any board you're serving.
yeah, and I agree with that, but I'm not seeing the difference. of a
BOCC could be even a
member.
criminal penalty.
And that's fine, but I don't see the difference of a BOCC member being on a board, being on a director of a board of an organization that is
I
clearly,
think you're not
making a
listening.
favorable-
I think we're saying the same things. You're not listening. So when you
no,
have
I'm
a
listening.
BOCC member on here and has been substantially disclosed on here that they have a financial interest in it, then I am saying it is a conflict.
Okay, but you just said a minute ago that if they're on a board of director, that's not a.
Mark, you asked me about governmental mark.
Mark,
Mark is-
climate,
You're trying
climate
to, okay,
act.
let's take a breath.
Right. The Climate Act, though, is very, when they're calling in, okay, because this isn't very different than two of
Okay,
the.
so let's get back to.
I know, hold on, let me finish. I won't interrupt you next time. We had two members that the whole point they were having to recuse themselves was because they had members of their
Are we talking about
employment.
BOCC or planning commission?
Both. I'm using both as examples of what happened on planning commission and kind of the examples you're giving, but yet it doesn't seem like this is translating to at the same level of when BOCC members are kind of doing the same thing. We had people from the Climate Acts call in as citizens and give their, their 3-minute spiel of why they were pushing solar. Same with Mark, all of that. So, and if you're on that board of those people that are calling in to support something, that pretty much tells you where your support is and where your liaison is. We had two members
Okay, so
on the,
if I can
two
interrupt.
members on the planning commission that had to recuse himself because one was asked to, but held his ground. The other did not, because they had somebody from their employment, didn't even know, it was just sort of a freak thing. And they were told that they had to recuse themselves because it was an appearance of the same thing. And it was a freak thing. They didn't even have anything to do with each other, but it was because they were from the same employment. So how's that different?
I don't know. I'm getting confused by your question.
What are you
What's
confused
your
at?
question? I don't understand your question in there.
Well, I don't know how to explain it any clearer.
Okay, I don't understand.
Is the Board of County Commissioners in a different conflict of interest and rules than board members?
Right now, Planning Commission, right now, we have the same, we're trying to have the same standard that applies to the Board of County Commission apply to boards and commissions. We're in that step. So we're in the first stage is tomorrow, the rules of order, which would determine the conflict of interest. So we want to make sure when we move out to boards, we're all using that same standard. So that, to answer your question, they will not ever have a different standard. Right now, it is too broad, the standard that is included. And what we're trying to do is to get in line with something that's more measurable and that we can determine. And it also provides us the ability for you to know if you have a conflict.
Understand, thank you.
All right, Kelly Ross, so if I say if I was on the board of Mark or on the board of the Climate Action and sat on the Planning Commission and the solar thing was still going on, and somebody from the Climate Action and Mark called in giving their little spiel, would I have to recuse myself?
I don't know. I don't know the answer.
Well,
I need
why
more
not?
facts.
You're
I would need
designing
more
this.
facts. I need more facts.
Oh, I told you the facts. I'm a board member.
I need more facts. I don't have enough facts. I don't know what I'm not going to sit here and speculate with you and go down that road, because what you're attempting to do is go in a direction that you're trying to take what I'm saying out of context because you have a personal belief that a person has a conflict. And I'm trying to tell you, we're trying to move.
The Kelly Ross, that's not what I'm doing. I'm trying to just get clarification. So please don't say what you think is personal, what you don't. I'm honestly trying to get clarification because this is an issue there. And I want the continuity. I want the consistency, but that has to go across and span across all. So that is why I'm asking. I'm asking you a very clear question. If I was sitting on a certain board on this side, I don't understand why that, what should be good for the goose should be good for the gander. And I'm just trying to get.
I've
a
heard that
feel of
statement
that.
before from someone.
Yeah, I don't understand that.
Okay, I'm not going to sit.
Look, I'm not,
argue.
I don't.
I'm not
appreciate
gonna
being
argue
snarky.
with
These
you.
are, these are sincere questions. I'm really trying to understand. You're here to explain this stuff to us. And I'm really kind of offended at the way you're coming across. I'm sincerely trying to get an understanding of the perspective of what you're trying to say. And you're being really cynical and sarcastic about this.
I apologize if I'm coming across,
you are
but your
coming across
tone
that
is
way.
also accusatory.
Well, I didn't
So
start off that way. I'm
what
just
you're trying to
defending
do
my
is to
position
go
of why
after
I'm asking
members
the
of the
questions
Board
I'm
of-
asking.
What you're trying to do tonight is to go and get me on the record, recorded.
No, I'm
and
not.
say-
Sincere question.
Well, let me finish.
Yeah.
You're trying to get me to go with Board of County Commissioners that they have a conflict. And at this point, if you feel they had a conflict, you need to submit a complaint. My team of attorneys, we will review it and we will give you an opinion. But I'm not going to do this on the record where it's a confidential proceeding because you're trying to play gotcha with BOCC members.
I am not, for the record, Peg Trent, I am not trying to get you gotcha. If I wanted to do everything that you said, I think you know me well enough that I would be in your office and I would have already done this. I am truly, honestly, for the record, this is Kelly Rast speaking. I know what my intentions are, so please quit saying what my intentions are. My intentions are sincere, trying to understand, because so far since I have been on this, the zoning board and the planning commission, and I've witnessed and started partaking in government stuff, even what has happened recently, I do not see a lot of consistency. And so I am sincerely trying to understand where you're coming from and to kind of get an idea, because we're going to be voting, not tonight, but at some point we'll be voting on these bylaws. I want to understand. So despite what you're trying to spin it, I am not trying to get you as a got you. These are sincere questions. If I'd wanted to got you or do anything like that, I would be in your office.
Okay.
So please stop.
So to
putting
answer your
words in my mouth.
question, there are numerous board appointments that the Board of County Commissioners serve in their capacity on various advisory boards and commissions as a liaison. They do not vote on those boards. They sit there in an advisory commission in a capacity. Mark has various boards and sub-boards, and I'm not familiar with whether they vote as a voting member. One of them they may, and I'm not positive. And we looked at the compatibility of the offices, so it's not conflict of interest or compatible, meaning can you serve on one seat and be on this board over here, and are they compatible? So there's other issues outside of conflict that would be under code of ethics, not under this. So at this point, it depends, and I'm not trying to be coy or play. I would have to analyze the situation from that lens of a specific item and whether they voted on it and then voted over here. That would be a conflict. But if they're not voting and they're sitting as a liaison and they come in and it comes, in front of them, then that is not a conflict. It'd be no different than, and I'll use her, Commissioner O'Hara goes and attends a planning commission, a zoning application, because she wants to hear what was from the public comments, what was said, what your questions were, and she wants to know. Commissioner O'Hara is a liaison to your board. So Commissioner O'Hara comes in on that zoning application. She would disclose on the record that she attended the meeting. She heard the public comments. She heard all of the comments. She's done what she needed to do in disclosure. She wouldn't have a conflict because she attended this board meeting. It's the same thing as if you attend another MARC meeting or any other meeting that deals with climate action and you're not a voting member, but you're a liaison, then you do not have a conflict because you're listening, but they disclose it. And that will be part of this, of disclosure. So at the ex parte communications and disclosing. So where I'm going, it depends. There's various, MARC is very large organization with various subcommittees and different items. And that's why I'm sitting here telling you it depends, and I would have to have more. And that's why I feel I'm being cornered into something to later have a transcript. And you have to know, I'm very, something I said now is being used and taken out of context in a transcript. And that's why I'm concerned tonight to go and say something and have someone use my words. That's not what it meant, because context is really important when I'm talking about a certain item. You can't apply what I say here to another item that may have different facts that are applicable, if that makes sense.
Total sense. I have no problem with Kelly Rouse, no problem with that. The difference was when you know the position of the group in itself on a certain item and somebody is involved in that, that's probably the biggest difference compared to like the analogy you gave. If you know what the groups and they're sitting there being an active participant in the dialogue of what's on the agenda and you know what their stance is, I think that's the gray area that needs to definitely be looked at.
Well,
That's it.
This is Ken Klingensmith real quick. But what the county is looking to do is this conflict of interest, the Board of County Commissioners, all the boards, all the appointed positions are all going to govern under the exact same rules.
correct.
And the code of ethics that's referenced in 4.05 is the code of ethics for Johnson County government that we were provided earlier in the year.
Yes.
That being updated tomorrow.
Yes.
Is that what I-
Not tomorrow, but on
or being updated.
February 9th, it's going to come forward in front of the commission. Board of County Commission in a COW, Committee of the Whole, where they're going to review it at that time with suggested changes. And then if they direct staff, then we would bring it forward in a regular meeting for adoption. But right now, they're just starting that first step of the rules of order.
So the code of ethics, conflict of interest, across the board, equal for everybody, applied equally for everybody
Correct.
where you're moving.
Correct.
All right, Kelly Rast, the Code of Ethics for Johnson County Government, where does this stand? Is this going to be consistent too with each board's Code of Ethics and everything too? Is
Yes,
this getting reviewed as well?
yes, this comes up on February 9th in front of the commission
Okay,
in a committee of the whole, and they will review the revisions. So that's why we started this conversation with all the zoning boards, so that once they finalize it, and if we're doing it consistent, then at the time that's adopted, then these bylaws, then you'll come through and then move forward. And we're trying to have a template so that we're all on the same page, having the same rules for all board planning and zoning boards and all boards throughout the county. Okay, other than that, there's no real major, it's kind of just, if you read through it, I'm trying to think, public comments was, I will call that out. There was a discussion of whether in the agenda, there should be public comments. I think the other zoning board wanted to know under page 6.07, Southwest Zoning Board wanted to know, why are we doing public comments? Because you're just an advisory board. Then you do application where you do take public comments on applications. So they wanted to know why we didn't do public comments. And I told them that it's my understanding, it's the direction of the commission, board BOCC, that we do allow public comments. So someone could come in from your jurisdiction and say, hey, I don't like the way accessory buildings look, just in general, not related to an application. So that's why that's in there and consistent with what the Board of County Commission has been doing.
You're saying that would be in there.
That would be in there. There was a request of why do we have it? Should it be removed? And why, just kind of why do we have that? So that
So that
that's there.
would become a separate agenda section then, I'm assuming?
Yeah, that would be
Or
right after
under new
roll call.
business or
Mhm.
Right after roll call.
Yeah,
This is Sean Penley, planning staff. I want to clarify that because that is often a common question. We have, there's a difference in the planning commission and the zoning boards. On the planning commission agendas, Peg, you may or may not know this, we do have a specific section. We call out for public comments at the beginning of the meeting because they are more
Right.
legislative.
right.
We do have that on the standing agenda. On our zoning board meetings, we've never done that traditionally because we have public comments at the time of an application because they are public hearings.
Right.
But we could also add a
Yes.
specific section for general comments.
I did add that on because that's consistent with the county commissioners. It gives people to give you as an advisory board their opinion about accessory buildings. They're getting too big, too many.
Right.
So yeah, if the board agrees, I would say that we could add that on the agenda. Yeah.
I would recommend though that we add it at the end because they're gonna have been here and heard cases and questions or comments may arise out of the cases. That makes, that are, and we've had that happen a few times where the comments kind of swerved off of the case and they're, maybe we're discussing a building setback
Right.
and the applicant has followed the rules, but people are saying, well, that's too close.
Well, no,
And so
these are
that's a
public.
general question or a comment.
Right. No, this wouldn't be the public comments on an agenda item. This
No,
would
that's
just,
that exactly, but I'm saying comments on an agenda item may swerve off into the general. Okay?
you're saying they'll come in early.
No. Just listen to my example again. So we have somebody bring a case and say they followed the rules, right? And staff's recommended approval. And maybe the building setback is 25 feet and the building is 3 stories tall. It gets approved, people don't like it, and we tell them, hey, they followed the rules. If you don't like a 3-story building, 25 feet from the property line, you need to make a general comment outside of the application to be considered for a rule change.
Mr. Chairman, Jay,
Yes.
just if I can add something to that as well. I think to keep the order, the way it, including it in the bylaws, and then as the chairman, and you could make a motion at the beginning of the meeting to change that order if need be, because that won't happen obviously on every meeting, but you
Sure.
have that flexibility. And the previous zoning board Southwest talked about that as well.
Okay, all right. Thank you.
And this is kind of nice, public comment becoming the zoning violation complaint zone. Because when they're not getting responses from staff, when they're not getting the answers they want, they're going to come here, rightfully so, and use that as the opportunity to report violations.
Yeah, well, I think if it becomes that, I mean, that's different.
Hmm.
I mean, that's something that needs enforcement, not a change. But it could. Yeah, I hear you.
Yeah, and this is Kelly Ross. We had one recently at the Planning Commission where somebody, basically, they've been fighting for 5 years or more, and they brought it up on the public comment. And then I also have a question with that, with the public comment, since we're trying to be consistent across all boards and stuff, is the public comment for our zoning board and stuff, is that going to be aired via Zoom for anybody who's watching to hear?
Do we put this on YouTube?
This is on Zoom,
Oh, it's not on YouTube.
on YouTube. now.
Okay, yeah.
But people can watch.
Is it on
live.
YouTube eventually?
It is live via Zoom webinar. We record that, and the method the county uses to post that recording on the website is via YouTube. The Zoom webinar recording that is downloaded from this meeting is then posted for later viewing on the county's YouTube page.
So maybe it is best to just take off the public comments in general and then just have the public comments on the agenda items then. It's a good question. Thank you for raising
Well,
that.
Kelly Ross, I disagree. That was not my point. The point is that the public should always be able to hear what's going on. And the reason I was bringing that up was because the BOCC recently made a motion to not allow the public to hear public comments anymore, which a lot of people, well, most people who know about it, which isn't very many, are not a fan of that because it's excluding the public from seeing what's going on and giving them access to what's going on in the county. And so I'm
That's a good point.
100% think that that the public should have access to hear what's going on in these boards. And so
Okay.
if we all agree it should be heard on the zoning board, then I would bring that all the way up to the top for consistency.
Okay, let me follow up on that. Thank you for bringing that to my attention. And so that's an item I need to follow up with too. Okay. Thank you.
This is
I
Fred.
know
Wingert.
Southwest didn't want it.
Fred?
This is Fred Wingert. I had a question. If there's a vacancy right now on the Southeast Johnson County Zoning Board, how is that filled? What's the?
Right now, that would be Commissioner O'Hara will be picking that appointment.
Okay.
Just so you're aware, our current tomorrow, if the rules of order go through the county commissioners, they'll be repealing a resolution on appointments through their resolution adoption of those rules of order. Right now, during the review of the rules, it came to light in reviewing the resolutions that the county has been appointing contrary to what's in a resolution. And so we would be repealing that, and the rules of order took out that process at all. And so I was directed by the CAL to come back to the board with some, I guess, kind of understanding the process so that I can report back how board appointments look right now. And so they have a better understanding of what, the volume and how it looks. But right now, we've been following the process that since this is in the jurisdiction of District 3, that would be Commissioner O'Hara that would continue to appoint.
This is that actually brings me to my point on section 4.01 under the composition and qualifications. It was historically my understanding that in that first sentence, It's actually appointed by our third district commissioner and then potentially just approved or signed off by the Board of County Commissioners.
Mhm.
But that the appointments to this board would be by our elected official, which is
Right.
third district commissioner.
Right. No, what happens is the county commissioner nominates a name. It goes on our consent agenda. And under state statute, you have to be appointed by the Board of County Commissioners. So thank you for the correction. All the nominations for this board would come through Commissioner O'Hara. And then those go on the consent agenda, and that's within the rules of order tomorrow that they would be adopting, and then they bring them on for approval.
So it seems we should tighten up the language to state what you just stated as part of the composition and qualifications.
Okay, so I could add well, I don't want to do that yet until we have that understanding in, because I have to report back to the board and I don't know which direction they're going. The current resolution says it's to be all appointments are divided equally among all the district, and that's what it says. It isn't the chair, it's all of the districts. The chair only gets certain appointments, but all of them are to be done equally. And I don't think, and I pulled all of your resolutions to see, did we deviate from that for appointment on boards and PC and zoning specifically? And we didn't. We were silent. So then you default to the appointment, which is in our rules of order and that. And so that's where that was discovered when we went through the review. So at this point, we're just continuing the process that we've been doing. We just wanted to make sure we got rid of that so someone couldn't say that's the process. The process we've been doing is you nominate and then adopt. And there's nothing in writing on that then.
Thank you. This is Ken Clay-Smith again. I also, under the compositions qualifications, and I don't know if this was written, but when we consolidated the two zoning boards, it was understood that Aubrey Township would have 4 seats and that Oxford Township would have 3 seats to create a balanced board. And the way this reads, you could have all 7 members from Aubrey Township, which then properly doesn't represent the other area of the unincorporated county.
I know, looking at the resolution, do you have that in front of you by chance? It says they picked it right from the resolution, what it said. So they may have discussed that and represented that to you, but in the resolution in 17, this is lifted directly from that resolution.
Yeah, this is Sean Penley, planning staff. That's a good question, Ken. I was curious about that too, because I was not here at the time this board was consolidated, and there was 2 different resolutions. One was for when the Aubrey Oxford Township was consolidated to form the board at that time, and it did have specific language regarding that. Then in 2017, another resolution was adopted when the Aubrey Oxford board was consolidated with the South Central board, and at that time, a lot of that language changed. And so maybe in 2017, that most recent change may have affected the membership and the balance there, because it doesn't reference any of those specific balanced location of the township.
That was in September of 2017.
Yeah, 2017. And I think what I can understand from reading the history of that, it may have had something to do with the fact that it was consolidating a larger board area, including parts of Spring Hill and Olathe townships. And that may have, because there were so many townships, maybe that sort of complicated things in terms of balancing. I'm not sure the reasons behind it.
So we may want to revisit that.
I was going to say, since we're moving forward, looking at bylaws, it seems that would provide a consistent representation.
Well, it may be consistent, but I have to follow what's in the resolution, which is,
Change the resolution.
yeah, we would have to go back to the Board of County Commissioners to change that resolution. So, but right now,
Wow.
moving forward, it would remain the way it is. But you're right. You know, I'm going now looking back, trying to get boards and commissions in compliance. So that's why we had the oaths of office, all of the acknowledgement, making sure you have all of that.
The other component that I wanted to comment on is the the township boards. So you have the Aubrey Township Board with elected individuals, and you have the Oxford Township Board.
Right.
It used to be that those boards were provided a seat as an elected official on the zoning board,
Mhm.
and that had passed away as well. And it seems like that would give great local representation to potentially reinstate that or have that be a consideration in appointments as a composition or qualification, because each board has 3 elected individuals. One of those 3 could represent on the board and be one of the 7.
Well, there's nothing precluding the next opening that Commissioner O'Hara could use that as a guideline now.
Well, no, but I can appreciate that, but she doesn't have to.
No.
Or if we can write it into the bylaws, that might be something.
We
for
can't,
discussion or
you can't
consideration.
put it in the bylaws. It'd have to go into the resolution back to the board before you could put it in your bylaws. You don't have that authority. It has to come from them revising it.
So it seems like we'd have to do a resolution before we'd agree to these bylaws.
Well, you have to have bylaws because you're not in compliance with state statute. So what we would do is adopt bylaws, have them go to the commission, adopt them, and then make the Board of County Commissioners aware of the situation when we bring the bylaws up. And then that would be the dialogue that we would have at the commission to direct me to do a resolution to correct that at that time. So that would be the vehicle to make that happen.
Or the board won't approve the bylaws, make the resolution, and you get your bylaws approved and get compliant.
Or the board, if they don't approve bylaws, that's going to be an issue because you have to approve bylaws.
So that will fast track my resolution. Sorry. that's
Kelly
just a
Rask, can it
comment.
just be done in parallel? I mean, for the whole year I've been here, we haven't had bylaws. Why don't we want to get them done correctly? And can't the resolution and the correction of the bylaws be done in parallel?
So what if the commission says, no, they don't want to do it that way? Then you don't have bylaws?
I guess
You know
so,
what I
until
mean?
until we figure this out, but
I think your bylaws are how you operate a meeting. So we just need to move forward and then work out the other.
I respectfully disagree, but
Yeah.
go ahead.
So
I'm sorry, could you repeat that again? The bylaws were what?
The bylaws are required by state statute and they're
No, you-
here for your.
No, you said something that bylaws were.
Oh, yeah,
for
they're
how you do
They're
the
for your
meeting?
meetings. Yeah, they're for your business. They're supposed to be, as it says in the first paragraph, that these are for, or the second 2.0, these are for your operation as a board. So how you're operating, it's more your regulation as a board, how you're operating. It's not about your jurisdiction or about anything. It does carry over what your jurisdiction, because that's telling you what items are coming before you in order to act under the state statute. But it's not, your purpose is to review and submit recommendations on the approval of subdivision items. And basically you're to look at these rules as how you're going to operate as a board.
Kelly Rask, but also discusses terms of office, compensation, conduct, vacancy, resignation, which are all, that's what Ken just brought up of what would fall under that clarification of it. And just, I would say just, as you look at 401, just have the language consistent with 4.08 as well.
And this is Ken, my purpose is I don't want the board all to be Stillwell people, and I don't want the board to be all Oxford people. And I think we need to not say, well, that could be under great consideration. I think it needs to actually be stipulated that way so that we actually have representation across the area that we are making, we are advising on from a zoning perspective.
Okay, I'll talk it over with staff and take it under their direction, that we can have a dialogue offline about it, what to do. Because if that was the intent and what you had discussed at that time, it sounds like to me whoever drafted it didn't include it correctly. I don't know. So I don't know.
Commissioner Klingensmith, Jay Leipzig, I do remember some discussion with Commissioner Klicka on that topic. But yeah, and looking at, as Sean just read, and looking at the resolution, that language is not included. So somehow that part of it was lost. So yeah, we'll do some additional research.
Yeah, and if that was the intent to cover those jurisdictions, then I see what you're saying. So let me follow up on it and we'll go from there. So thank you for bringing that to my
Actually,
attention.
when we consolidate, that's when the township board positions kind of disappeared as well.
So this is Fred Winger. I'm sorry to ask the same question again. I just want to clarify. does this bylaw we're passing change the way we're currently selecting members of the Southeast Johnson County Zoning Board?
This bylaws has nothing to do with the selection because that's done by a Board of County Commissioner. So it has nothing to do with selection.
I guess for clarification, then I asked earlier how the current board was selected, the Southeast Johnson County Zoning Board was selected, and it was indicated the third district commissioner would nominate someone, and that nomination would go to the Board of County Commissioners, and they would vote on that nomination.
Correct.
Okay, and is that going to continue? Where does it say the third district? That's how we do it now. Where does it say the third district commissioner would nominate an individual and the board approves? It looks like to me we're changing the way the Southeast Johnson County Zoning Board is selected. Is that correct?
No, you're not. This is just repeating what's in state. This says this in state statute that you're to be appointed by the Board of County Commissioners. The nomination process is a separate resolution
Okay.
that told the commissioners how to do that. That's what we're repealing because we found out the county wasn't following that resolution and they were doing it the way that you currently are doing it, where the third district points all of them. So that is the resolution that's out there is wrong. It's not the current process. So we're trying to correct it to make it consistent with what we're doing as current practice. So the first step was to repeal tomorrow, if the rules of order, that resolution, because you aren't following the process that was out there, that it's equal. So this is correct for you, for your purposes under the bylaws, that you are appointed by the Board of County Commissioners. You are not appointed by the third district commissioner.
Right. No, I guess we're somewhat splitting hairs. So let's take the sixth district.
Yeah, Fred,
So does the sixth district commissioner for the Johnson County, does she or that individual, do they get to select the Southwest Johnson County Board? Is that how that works?
Yeah, they have the trustee like that was being discussed. So the ones with the trustee, those are done by the county clerk, doesn't even go through the chair. She just does the trustees. And then the remaining ones are by the sixth district commissioner. You are correct. She does the remaining.
So as a follow-up, is the intent to keep whoever the folks that are in the Southeast Johnson County district, whoever they elect to be their representative on the county commission, is the intent to keep them as the individual that makes up this board, or is the intent to move this to be a process by the entire board?
I don't know. What I was directed to do in the CAL that was held on January 26th is to bring back, because they want to know the exact questions that you're asking. Commissioner O'Hara asked that question of me in an email the other day, so I provided it so that she could see who's appointing what in these certain districts. And so the board wants me to report that back to them and kind of have that discussion of what recommendation, what they want to do. And at this point, I think, the direction from what I'm hearing is to continue to write something up that's consistent with the current process that.
Yeah, I mean, and I guess when it comes to other county boards, does the district, does commissioner from the third district or sixth district, do they get to appoint other county boards because they represent?
Yes, they've been doing that. So that would continue. So Planning Commission, I believe 4 members are appointed by Commissioner Allenbrand for the sixth, and then 3 or 4 the third district. For the sixth district, for the third district on the Planning Commission, and the remaining, because they have 11 members under state statute, the remaining are appointed by the chair. And I'm not sure why, but they're appointed by the chair, the other 4, and they're in the incorporated area. So, who knows?
Okay. So
That's
there's no
the way the current practice is.
So the
But Kelly,
current,
you're saying current process, and making it sound like we're going to stick to the current process, but you're also saying we're not doing it properly as the way the current process is written. So you keep using both those terms and I'm
Okay.
getting confused. So I guess what we want to know, I guess, and I don't want to speak for Fred, but what I'm hearing is going forward, it's kind of what's up in the air right now is that even though all the districts have been doing it this way, that may not continue. Is that correct? A correct
No,
statement?
no, that's not what I'm
It-
saying, because it could. I don't know the.
We don't know,
We don't
but
know.
it could change, is what I said. It could.
Right now, all I can tell you definitely is that there is a resolution and a process for appointing board members. The county is not following that process. At this point tomorrow, the intent would be when they adopt the rules of order to delete, to get rid of that because it's not what they're following. We're following this process right now. And if, just being a realist, if you look at all the boards and appointments,
Delete, we're talking about deleting.
not just you, the planning and zoning, it goes all boards. are
Right,
not
but I'm
being
just
done.
clarifying what,
But let me finish. So what happens is that's
deleting
gonna
the way
change-
it's being done right now.
Yeah,
that
we're going to
correct?
continue to do what we're doing because if you delete it, then everybody would be upset because they're losing appointments if we start distributing them. So this is a profound, if we start following that process, not only will planning and zoning, but other boards. So that's why we're sitting here trying to figure out the process to get it right. And I don't know how far reaching. I haven't checked every board to know that's what the commission wants me to report back to them. So we understand what are we doing, document what we're doing. If that's the direction we're going, then we adopt it. But we don't know how far reaching this is of non-compliance. I just can tell you from planning and zoning, you weren't doing it correctly.
so.
Hey, Pat, this is Dan Foyle.
Right.
Sorry to interrupt.
Go ahead, Dan.
I got a quick question. So we just got this, or I did anyway, at 8:50 this morning, and I had to work today, so I didn't have a lot of time to go through it. But what I'm hearing from you and what I'm reading in my mind isn't matching up. So help me understand where it says the person in our district nominates us, and then we're appointed by the Board of County Commissioners. And then also, if you wouldn't mind, while you're doing that, show me where, in this case, Charlotte would be involved in if there was a vacancy as well. Because what I'm reading in the vacancy part of it is that it gets appointed by the Board of County Commissioners. And I don't see any involvement in, the person that was elected as our representative.
You are reading it correctly. 4.0 and 4.8 do not say District 3 Commissioner or a District Commissioner. It says the Board of County Commissioners because that's what's lifted from the state statute. The Board of County Commissioners adopted a resolution on how appointment of boards would occur. And in that resolution, it was adopted many years ago. It outlined how they were to do the appointments and who selects whom on each board. Unless it's in the actual resolution that created that board. And there are over 30 boards. So that's the process. Your resolution that created your board and the zoning boards and planning commission did not give direction as to which commissioner is to appoint from each of your members. So you go to the general resolution that was from years ago, and it conflicts with what your current process is right now.
If
So
I-
we cannot put in your bylaws that this is the process because that is not your authority to determine who appoints. That's the Board of County Commissioners. They have directed me, we're getting rid of it because we're not complying with that, to now come back to the board. We need to have a plan. I need to go through each of the 30 boards, find out, are there other boards and other commissioners? Is it going to affect them as well for their appointments that they may have been pointing 3 or 4. Now it's going to change so that we know the far reaching effect of that. And then at that point, the board make a decision of what's going to occur. And I can tell you right now, to the best of just guessing, it's going to affect probably at least 3 or 4 board members. So, I mean, that's going to change their representation. So, what I think right now is we just need to figure out what it is, the extent of it, and correct it. And if that's the direction of the board, then it will codify the process we're currently going in a resolution. And
So the
then
Board
later,
of County
So I
Commissioners-
want to,
Oh,
I want
sorry.
to just clarify my questions from earlier. It has nothing to do, my questions have nothing to do with what commissioner gets to appoint what. Our questions have to do with the person that's appoints the Southeast Johnson County Zoning Board should be the person that's elected from the Southeast Johnson County area. So there's been a lot of comment tonight about this commissioner gets to appoint this and this commissioner might be upset. I think the citizens of Southeast Johnson County deserve to have the person they elect, whether, somebody that we voted for or we like or whatever, doesn't matter. They're the ones that were elected to represent our area. They should be the person selecting the zoning board that impacts our community. And to me, I don't.
yeah, I'm going to take that back to the Board of County Commissioners so they hear that, and that makes sense. Because it's your
I honestly think that the Southwest Johnson County Board, I know several of the people that are on that board, they represent very similar areas. I would think that they would feel the same way about the 6th District Commissioner nominating them.
They listened to what I had to tell them about how we're in the process of making that determination, and they didn't comment one way or another. I just wanted to make sure they were aware of it, that this was a discussion that was going on. So I disclosed this to them too. So I mean, at this point, this is an issue for the Board of County Commissioners. At this juncture, I'm just delivering the message. So you have these bylaws, you're aware of the issues. We're trying to move in a direction to fix it, but it sounds like you've got other issues in your resolution as to jurisdiction that we need to address too. So there are issues you brought up tonight by going through the bylaws. So I appreciate that. So we'll carry those thoughts along to the commissioners.
So do we need to memorialize the 3 or 4 concerns that we have? Do we need to have a motion and get it in the record, or how?
No, at this point, it's already in the record. So they do verbatim minutes you do of these meetings. So it's in the record. So we will have that when we bring it forward. And then you also have your commissioner present. I'm sure she'll bring it up too, and we'll make sure that they're aware. But I'm doing a report, so I could incorporate your thoughts in it. And we'll ask each of the zoning boards too. But the resolution is something as to jurisdiction. If that was the intent, that's not what was written. So that needs to be addressed too.
So Kelly Rass, as it stands now, and if nothing changed and the language stayed the same at some point when it gets passed by the commissioners, then District 3 commissioner would not be appointing anybody to the southeast.
That's not correct. It depends on what the board, you twist it. It depends on what the board does. At this point, the board.
Well, no, I'm saying if the board doesn't change anything and takes what you have written here and adopts exactly what it says.
The
then-
bylaws here.
Yes.
Okay.
And that we go off of these bylaws saying that it doesn't specify that the District 3 commissioner appoints the board members.
No, they are right now following that process. There is no change to that process at all. We had this discussion during a COW that the process will remain the same, and I am directed to come back with a report. We are not changing the process. They discussed that on the COW. They made it clear to me I was to come back and report. So nothing's getting changed. We're just going to follow the process we've been doing, where District 3 is appointing, District 6 doing hers, and other districts too.
So why wouldn't we clarify the language in the bylaws?
Well,
I'm not clarifying it.
I think this is premature.
Okay.
I think the
I'm not
county
asking you to
commissioners need to
vote.
do what they need to do first. This should be a future topic. And we clearly need to have a resolution go before the board to put back potentially the intent if the board here, the zoning board agrees with my comments, this is Ken on 4.01, get the resolution, and then we can pass bylaws that actually match what we believe.
Right. And I'm just tonight, my purpose was to start these discussions and to be open with you. I was trying to be transparent so you knew all these issues so that we were having this dialogue and you weren't surprised down the line. So that's why we've been going out to the board. We started with this document and moving forward to see what you are. And now I'm hearing about other issues too, and I'm incorporating and carrying those back. So the other one I want to bring to your attention, which you've already been doing, is 6.06 with ex parte communication. And that was perfect how it was handled tonight. There's no other, I'm trying to think there's any other major change. Oh, public comments and participation. I did notice an error in there. Just basically that you have a public hearing. So Planning Commission doesn't have, well, sometimes they do have public hearings, but not like you do with applicants and everything. So we did a public hearing, like how that occurs. So we codified what you're currently doing. And then in public comments participation, so I'm on 6 and 7, page 7. So on page 7 and 6.10, we talked about public comments and participation. And at that point, just kind of giving you what a person can talk about, which is legal. The Board of County Commissioners' current rules were not in compliance with law, state law and federal law. And so although the commissioners have been following what the law is, the rules were behind. So this is consistent with what they're, and if they adopt tomorrow of their language, the only thing I would remove is and appointments, because you're not part of considering of appointments. And that was just a carryover from there. So what I was doing is copying from their rules into there. Other than that, this is all consistent.
This is Ken. I have a clarification question. When we look at the conflict of interest, or we look at the whole 4.06 conflicts of interest, historically, it seems that if we were in 1,000 feet of the property, we were excluded or we had to abstain from that. And it's not really stipulated here. It kind of says, even if I'm within 1,000 feet of the property, as long as I don't have actual potential financial gain or loss or a conflict of interest, then I wouldn't have to abstain. And that seems like that would be a change for us. And
I didn't, who imposed the 1,000 feet and where did that come from? That's not law.
I think it's Sean Penley planning stuff. I think where that has come into play, where we have an application, if one of those zoning board members lives within the 1,000-foot notice area, they're often encouraged to abstain from voting, given that they may be have direct ties or information. Could be neighbors, people who they would have an influence on, or potential conflict of interest if they're within the 1,000-foot.
Okay. So when you look at the conflict of interest, if you go to that statute, the rule 4.06, any member who has a pecuniary interest, so your housing could have a pecuniary interest, some direct or indirect, personal or professional. So your residents would, if you knew that this issue would have a financial effect on your property, let's say putting a, whatever, a racetrack or something next to your pot. That was a bad example and bad joke. I apologize. And so let's say that happened, then that would be what you would argue. And so that's how you would fall under that.
But we don't have stipulated, it's more or less just gonna be generalized moving
Right.
forward for us.
That's why the state statute to catch other things. So you have that second part of or, which is the state statute, that form I had, that goes into more broad, so that we're not only looking for what's under the state statute, we're also looking whether you have a pecuniary. So we're looking at that financial interest or effect. That makes sense.
Thank you for the clarification.
And so other than that, I think that's all that I think all the others self-explanatory. Oh, telecommunication voting. Oh, 6.14, page 8. It just provides you the ability to vote by telecommunication now, just to make sure it's in your bylaws. And
This
allow
is
that to occur.
I had a statement about the statement of financial interest. Is that's being proposed that everyone that's on a zoning board completes that?
Yes, that substantial interest statement, yes. And, we
Right.
haven't approved that form by the board, but it'd be something similar to that. I probably would, tone it down, but for the boards, yes, that you would complete that. That would be confidential, held in the legal department, so that the legal department has those forms. Whenever items are coming up, we're checking for conflicts.
What about the other
Hey.
boards in the county? Would that apply to every board in the county?
Every board. My office now is assigned. I know I have my two attorneys on. They now are assigned to boards. So every board has an attorney assigned to them now. And so their attorney would be reviewing those.
So if someone were to file an open records request to see a member of the Southeast Johnson County Board's statement of financial interest, would you be obligated to release that?
No, it would be confidential under the proposed, in which the board has not reviewed yet, the code of ethics. I'm proposing that be confidential.
So if it was requested, you would have legal standing not to submit in an open records request?
Correct. Because all the proceedings under ethics and review is confidential. The Board of County Commissioners are public record. Because they're
Yeah,
elected
They're
officials.
elected, right, exactly, okay.
Yeah, they're elected officials.
I think, my feedback, I guess, would be, you're talking about hundreds and hundreds of people that, may or may not want that information, handed over. Most people that own corporations, there's other ways to find out this information. And at some level, you gotta have some trust in people that, I understand, statement of conflicts of interest and those things, but it would seem like it might be a mighty job. When I look at, all the different, you're talking about the levels of compensation and it could be quite a job, in my opinion, looking through all that.
Well, I think what will happen is we're not checking it out whether you're telling the truth. It's what you've disclosed. And so what happens is if it comes up that we're voting on an item and it's on your, we're doing a check before the start of a meeting to know whether you have a conflict. That isn't going to be that difficult to run through 7 forms to see. And yes, you could say, hey, we're going to rely on people, but who knows? They don't know if it's a conflict. And then we learn from the public and receive a complaint. And the complaint based is not best. It's better that we know up front, that we're looking at it up front to make sure that you don't have a conflict, that we're working with you so that you don't step into something and vote on something that you have a conflict. It's just good practice to do it up front, and also if it's complaint based.
So just to clarify then, if we submitted our statement of financial interest, before every meeting, your office is going to review the applicants coming before us and seeing that if any of the 7 members on this board have any connection to any of the applicants, is that?
No, you will sign it. You will file it with us once. You have an obligation to update it yourself. Once you file it, it's on file. So let's say this goes into effect May 1. You would submit it to me, to my office. We would gather those forms. And from that point forward, I would envision, and that's if the board approves this, then we would review those forms with the agenda items that are coming up, because my staff's working on many of these items, reviewing and discussing way before it ever lands on your desk. So we know. And they will be able to review those forms and make a determination to tell you in advance so that you're aware of it, that it's coming. So it's not, just you're here in the meeting and a surprise. And it'll be on you thereafter to update that form if something changes. We could say at the very least every year you update it, take a look at it and re-sign it just to keep it fresh, just to make sure there's nothing overlooked. But that would be the process that I was proposing. It may get shot down by the commission. I don't know.
This is Kelly Rass. Could you give me some guidance regarding HIPAA? I'm a physical therapist and see private clients and take money from them for my services. So, but
You
from a
wouldn't
HIPAA
disclose.
standpoint, I can't disclose.
Nope, you would not disclose.
Okay.
You would just say, I have a personal business where I'm seeing clients and you're just going to have to be good about it. It's just like, I
Okay.
hate to make the analogy, but any other person who has those requirements, and I hate to say it, an attorney or others, they have that same issue. And we can't require, nor would we. And I know there's an AG opinion that probably would force it, but if I was in that role, but at this point, we would not do that.
Okay, thank
That
you.
is not, you have a higher standard than for us to require that.
Okay, thank you.
And my apologies, because you mentioned this earlier and I forgot. But what about NDAs?
Yeah, same thing. And that's really a concern of mine. If you have an NDA, then you cannot disclose. So
But to me, then the proper thing would be if I signed an NDA, but I know,
right.
then I need to conflict myself out,
Right.
correct?
Right. And it's a two-way, but we're trying to catch the ones that we know are obvious before, to work with you to give you that protection and moving forward. And so what you may have a business, a private business, and then you have an NDA, you don't disclose those. And you would just say your business. You can't get into those clients because you have a disclosure issue. Also, that's going to be a lot. Some people may have 100 clients and they may not have HIPAA or some other type of business. Let's say it's a lawn care business and you have all these clients. We don't want you doing that. You just say that you do lawn care, but it's going to be on them to be able to disclose some too.
Right. Okay. Thank you.
Okay, I think I've gotten through. This went later than we thought. But I think we, at this point, we will bring this back in a month. I think I've heard a lot of what needs to be amended. And there was some good discussion of other items. So I will follow up with that and we will come back in a month. Hopefully, if there are the rules and ethics, then we can talk about that again. So we have another conversation. So this could take 2 to 3 months, depending on if we have to do a resolution simultaneously, whatever we're doing. Okay.
Mr. Chair, Jay Leipzig, this item would be brought before you then on March 1st. It would be your next meeting.
Okay, and I have one question. Kelly Rass, can you remind me again for a CAL meeting? Is that just something, are we supposed to attend those or the committee of the whole can you remind me? I know with the planning commission, we were supposed to go to those. Is that?
I don't know that. Committee of the whole is for the Board of County Commission. It is open to the public. It is in the hearing room and they are recorded. So you can look at them online. You can attend if you want. They're public, but there's no requirement that you attend. If you want to attend this one that we're going to be doing, there's no public comments, but you can watch it or you can watch it. I think they tape record those and they're on YouTube.
Okay, thank you.
You'll have access to it so you can hear it.
Okay.
And
This
the
is
ones
from-
we had previous CALs, they're recorded if you want to listen to the one on January 26th when we talked about the appointments to the board.
This is Fred Wingert. Could you kind of summarize for me what you heard from the board as like our top 2 concerns about the bylaws? that you were
Yes,
gonna
I
share
want to
with
make
the board?
sure that I have it on the record that I've taken it up. The first concern is jurisdiction.
No, excuse me, that's not, I want to make sure that the people that are on this board that every Wednesday night, once a month, come and represent our citizens, that everybody on the board has had a chance to give their opinion and that what you take back to the board represents what the people on this board feel like that are participating tonight. So I don't appreciate being accused of getting on the record. I take my duty seriously to represent the people that live around me. And that's why I'm asking.
Okay. What I'm stating is what I heard tonight. You've directed me that you want me to inform the Board of County Commissioners that you want the jurisdiction to be examined because what's in the current resolution, which created this consolidated zoning board, southeast, that it did not include what was intended of other townships. And you want us to re-examine that. It is your preference that before you move forward with these bylaws, that you have that resolution clarifying that jurisdiction and or do it simultaneously with the bylaws, but you would want the resolution adopted. Secondly, as to appointments of commissions, you are directing me to tell the Board of County Commissioners that it is your desire that there needs to be the current appointment to represent the community of where your jurisdiction to be district commissioner, which would be 3. That would be the nominating and appointing of the boards, and that whatever document they needed to adopt would contain that. And or it could be included in your resolution when you change the jurisdiction to make sure it's clear about your District 3. So I have many options in which to accomplish it, but you're asking me to make it happen. And that once I've come back and reported back to you, then you will consider whether you will adopt these bylaws.
Hey Peg, this is Dan Foyle. I had one quick question also. So like I mentioned earlier, we got this at like 8:50 this morning. Is there a time frame usually that we have to be able to consider this before a meeting that we have to vote on it? For instance, I really don't want to get this at 9 o'clock the day of our meeting and have, that many hours because you never know what my day is going to look like, et cetera. So I don't know if that's something that, when will y'all have the resolutions adopted and that kind of thing? Does that make sense?
What happened on this one, just so you're aware, in your bylaws, I think it does dictate of what we have to do. I think it's 5 days prior. So it's in your bylaws now. What happened with this one? We were trying to get the current information after the cow so that I had the most recent that we were including in your bylaws. And I never anticipated that you would be voting. I just wanted to have this open discussion tonight to start the dialogue so you knew what was going on. I started last week with the Southwest. I'm going slowly with all the zoning boards, making sure we're having these initial conversations and being open with you. I reported all of this to Southwest last week too. So I am moving in that direction. So you will normally get them 5 days in advance moving forward now. I just didn't have this current. I couldn't put something in front of you until I knew what was occurring with the county commissioners.
Okay, thank you very much.
Okay. Yeah.
You're welcome.
Good discussion. Appreciate it. Appreciate everybody's time. Do we have any other business? I want to make a motion to adjourn.
This is Ken. I can make a motion to adjourn.
John Lloyd, I'll second. All in favor of adjournment, say aye. Opposed? Okay. We're adjourned until March, what is it? March 1st.
March 1st at 6:30. Thanks, everyone.
Thank you.